Ladies and gentlemen, thank you for coming. It's no small thing to ask a jury to come in to donate your time. On the flip side, it's a very important part of our government, part of our society. Good morning.
Good morning.
Please be seated.
Steve versus Leonardo Francisco Blundo, RCR 2023-124588. Counsel, please do your appearances for the record.
State of Nevada, I'm Robert E. Glennen III. Bar number 2143.
Good morning, Your Honor. Paola Armeni on behalf of Leonardo Blundo, who is present today out of custody.
Thank you. Good morning to each of you. Good to see you all again. We were meeting early. Well, originally it was set for 8, but there was a motion to dismiss based on double jeopardy filed, so we'll take that first. Frankly, expected that motion, given the ruling, continuing and granting the motion to dismiss. So are we prepared to argue the motion and or proceed? I mean, just want to make sure we're prepared to proceed because there's no point in the motion if we're not prepared to proceed.
The state's ready, Your Honor.
Okay.
We're ready, Your Honor.
Okay. And then motion-wise, kind of like the hearing last week on Friday regarding the question of contempt. I've taken sworn testimony from Mr. Glennen. We have subsequent affidavits that have been filed. Information was provided and some testimony given last week. The affidavits being of Mr. Blundo and then Mr. Glennon's investigator, I'll call it, I don't have the name off the top of my head. Frankly, my inclination is to take all of that prior information and incorporate it by reference and take notice of it, but that does not by any means prohibit either objections to that process or supplementing the record in any way on the facts. I think the facts are somewhat straightforward in this regard, but those are my thoughts. Ms. Armeni,
Can I, do you want me to argue?
well, yeah, I mean, but first, is there any additional or different evidence that we want to bring forward to supplement what we already have? Do we just want to argue?
Your Honor, I was just going to highlight, I know the court's very thorough. I know you have read everything, so I'm not going to go over everything that's in our motion, obviously. I also respect the court's ruling on Friday and understand the court's insight already coming into this hearing. So I was basically going to reiterate what I believe to be some important facts as to the totality of the circumstances in this case, and then make some additional argument based on some representations on Friday.
Okay.
With the order to your cause hearing.
Please.
Is it okay if I approach the podium?
Yes, and if you need to twist it around or do anything, feel free.
Thank you.
And the state has nothing to add to what we have already presented.
Okay, thank you, sir.
Thank you, Your Honor. So just to highlight some of the facts that we did put in our motion, the state originally dismissed this case on November 2nd of 2022. Thereafter, they filed another complaint about a month later. After that, we dealt with several what I'm going to deem discovery violations, which was very thorough and very extensive briefing and court appearances. Some of the court appearances the state wasn't even present at, that they didn't appear, but ultimately there were these discovery disputes that went back and forth. The court unfortunately believed at the time that it didn't have jurisdiction to dismiss the case when we had filed our motion to dismiss, but in lieu of that gave a pretty strong order as to discovery and what could not be presented by the state in lieu of some of these violations.
Extremely strong. Yes, I had a question there, because when I
Sure.
went over those documents, that Judge Glassen and the procedure he was, and information, I guess, is more important to my question that he was evaluating. The one thing that I didn't see come through in the record is any sense of rationale or reasoning is on essentially what the problem was, whether the law enforcement failed to collect information, if they failed to preserve it, if they couldn't find it, if it got lost. That didn't come through, so I was just kind of curious if there was any.
I don't know. What I can answer is that, at least from the police report, it appears that they did take pictures. They did get a copy of the video that Melissa Blundo gave. And by the way, our position was that it was exculpatory, so that's why it was so important. And the state had actually put some of this evidence as exhibits on their exhibit list when we were preparing for trial. So it's not clear after the fact. I think it's clear that this evidence did exist. What happened afterwards as to why we never got it, that's unclear.
Okay, all right, just want to make sure I wasn't
Yeah,
missing
no, you're
something.
not missing anything. I think it's still unclear as to why it was never given. And we just don't have an answer to that.
Okay.
Then after that, we have the Hill motion that was made on our first trial setting, which was August 24th of 2023, where the state deemed that Deputy Toll was an essential witness and the trial could not go forward. It was learned at that time that Deputy Toll had not been served appropriately. Judge Glennen denied that motion and we proceeded forward. And that becomes important for, I think, the next, our Bustos motion that happened on November 18th of 2023 when it was ultimately granted. And the state chose not to go forward, even though they did have Deputy Toll here, who they had tried to do a Hill motion on previously, claiming he was an essential witness.
What was the service issue at that prior trial?
I will give you what I believe I understood it to be, and Mr. Glennen can correct me if I'm wrong. I believe that there's a process where the deputies can receive service via email, but there was some problem with the service via email. That I don't know if he didn't accept it or he didn't get prior approval to do it that way, but it essentially had something to do with that. And another step of that was Deputy Toll was actually out of jurisdiction as well on that trial date. So we cited to the court, and the court's aware of the Hilton standard, which requires for a motion to dismiss on double jeopardy, manifest necessity, and then whether the prosecution is responsible in any way for the circumstances which necessitated the dismissal. The manifest necessity, I think, I'm just going to touch on it. I think it's really the second prong that's the strongest, which I did touch on it now when I said they could have gone forward with Deputy Toll as they deemed him an essential witness and chose not to, even though he was present in the courthouse on that day, and then maybe sought to continue for however long, a short continuance for Melissa to be present, but they opted not to do that. But it's really the second prong that I think is a problem here,
Okay.
and that's where the prosecutor or the state is responsible for the circumstances which necessitated it. Now, we cited Downham. I know Downham is slightly different because they didn't have service, but there are some important, I think, key notes in there, where in Downham, the prosecutor allowed for this jury to be impaneled and basically took a chance. They didn't have any confirmation and took a chance that the witness would be there. And I'm going to submit to the court that in this case, they took a chance. The opposition to our motion was a little bit concerning because I think now, even though there wasn't a declaration attached, the statement by the state was, well, she must be on her way up, I think is what they put in the opposition. I'm not going to beat the horse. The court's heard testimony. The court has a declaration of Mr. Fumo, but I think what was clear from all the hearings prior is we're working on an impression, not confirmation, not an affirmation, just an impression. But even giving the benefit of the doubt, because I know what the court's position was, she was subpoenaed, fair enough, so she had a subpoena, she should have been here. Well, Your Honor, that subpoena said 8:30 a.m. The conversation between Mr. Fumo and Mr. Glennen was, I haven't spoken to her. So even if Mr. Glennen had said to Mr. Fumo, well, we need her at 1 p.m., there was no confirmation that Melissa was going to be here at 1 p.m. because there was no further discussion. Melissa told the court under oath that the last time trial took place in August of 2023, that Mr. Glennen or his office actually spoke to her and told her to come to court at what time she needed to be here. She was represented at that time, but yet he had direct communication with her. So what I'd say to the court is, where the prosecutor's responsible for the circumstances that necessitated the dismissal here is, even if Melissa was served as the court found, the subpoena said 8:30. When she wasn't here at 8:30, there should have been a call made to confirm that she was coming, because there was never an affirmation that she was told 1 p.m. So as far as the state believed at that point, she was served and the time on the subpoena was 8:30 a.m. There was nothing further. There was no other confirmation. So when she wasn't here, I submit to the court that the state took a chance without confirming whether she was coming or not by proceeding forward and letting this jury get impaneled. Impressions when we're dealing with constitutional rights are a little bit scary. And I think the bottom line is you can't take a chance when you're dealing with a constitutional right. There should have been a confirmation at 8:30 when she was not present. That would have been the time. Would I have been happy? Absolutely not. But at least at that point, jeopardy wouldn't have attached. And he would have had good reason at that moment, the state would have probably had good reason at that moment to say to the court, Your Honor, we duly subpoenaed her. We got service back. The subpoena said 8:30. She's not present. We don't know where she is. But that's not what happened. There was no confirmation that she would be here at 1 p.m. So at 8:30, I submit to the court that they took a chance when they proceeded forward. Your Honor, based on the totality of the circumstance, and that's why I gave you the long line of, I apologize for that, but I think with you coming in sort of late, I think it's important for you to understand fully what's going on here. And unfortunately, the state's lack of diligence throughout this case just adds to the prejudice for Mr. Blundo here and the fundamental fairness that now we're picking a jury for the third time. The state's acquired 2 dismissals of this case and attempted at least one continuance that ultimately was denied, so there wasn't any prejudice, but we still had to respond to a Hill motion in writing. So just the financial burden on Mr. Blundo for all these mishaps that keep coming. And when you have a constitutional right that's there, an impression simply is just not good enough. You need confirmation. And we would ask you to grant our motion to dismiss.
You mentioned 2 prior dismissals. You had the dismissal without prejudice at the prelim because it
Yes.
was some sort of cross-county service issue question. And then the second one,
Was that yours?
all right, and that's what I wanted to verify.
Yes.
So I was thinking of the one before where they were forced to go forward and make that call,
They were.
and then it was the venue issue.
Yes, Your Honor.
Okay. Question regarding your, I hate to use the word, but impression of the standard, because the case law is not great. Supreme Court left it wide open on each case turns on its own facts. And they have this manifest necessity standard, and then they go, I don't want to downplay by any means, but all they say is it's a heavy burden. And I mean, it's clear from your argument, yes, these are constitutional rights. But they don't quantify it in any way and compare it to anything. And I searched through the cases again yesterday, and I don't see this as akin to any standard that we're familiar with and used to employing. So, whether it's preponderance of the evidence, clear and convincing. What are your thoughts on that?
And you're right. I mean, I think it's common. To me, it looks like if the prosecutor is somehow, I mean, the second prong, what we really focus on, right? What is it justified? Can we look at this, and I hate saying prosecutor because I'm not trying to be, I don't want to, the state, I'm going to use the state. I think
You're not personally attacking. No, it's they're phrasing it in cases.
Right, but I think when you're looking at, could the prosecutor have avoided this? I think is how when I'm reading this, is there a way that the prosecutor could have avoided a jury, there being a double jeopardy issue? And I think that's when you start to look at the conduct of what the prosecutor knew, should have known, and look at that area. And so that's where I think what we're arguing is the court has already found she was properly served. If he was under the impression that she was on her way up, if you will, or he was under the impression she was coming up here, I assume that's accurate. If he said that, I believe that that's what he thought, whether right or wrong. But even taking that impression, at 8:30 in the morning when trial started, and that was the time on the subpoena, when she wasn't here, I submit to the court, that's when it shifts to the prosecutor being responsible for the circumstances that occurred, because he took the chance, when she wasn't here at 8:30, he took the chance with allowing the jury to go, the trial to go forward and the jury being impaneled.
And so, taking that chance, the way they couch the issue, even in Halton or Hilton, they describe it as whether their decision to proceed was negligent or inexcusably negligent. So there's some sort of wiggle room for the circumstances, obviously, but any thoughts or guidance for me on that? Like how much wiggle room there's allowed for negligence as opposed to whatever inexcusable negligence is? I mean, I think it seems pretty clear from the facts of the underlying cases. The inexcusable is in one of them, they tried to go forward under the assumption that two co-defendants were going to show up for sentencing the same day, and so they'd be present and the court could essentially order them to testify. No subpoenas or just perhaps down them as well. You know, not even subpoenaing. I mean, that's an easy thing. Thoughts on that balancing, or if it comes into play?
I think I think it still comes down to what the information the prosecutor had at the time. And if they had that information, why they would allow, because again, I think it's two different areas here. If you make a bustos before the trial, if you have a witness that's been subpoenaed, time says 8:30, and you've never got any confirmation, because if you recall, Mr. Fuma said, I can't get a hold of her, I have not spoken to her. So there was nothing to believe that he was going to be able to speak to her from 5 o'clock that night to the next day. And there was no confirmation that he spoke to her. So there was no confirmation by the state that they went back and said, okay, Mr. Fumo, did you get a hold of her until 1 o'clock? We know that the state has had no problem communicating with Melissa directly to ask her or to see where she was. But that didn't happen. So when the subpoena says 8:30 and she doesn't show up, at that point, if they would have made the bustos, they would have had grounds to do it. But the neglect, or the inexcusable neglect, frankly, is to allow a child to go forward, spend all these resources and time, and panel a jury, and then say, oh, well, she's not here, when they should have known at 8:30 that she wasn't here.
Thank you. Mr. Glennen.
Yes, Your Honor. Frankly, in thinking about all the issues in this case, I had spent not any time at all thinking of the standard of proof. I think that might be a first impression decision. I could see it being clear and convincing. I could also see it being weight of evidence. Mr. Toll is an essential witness, and so is Mrs. Blundo. Regarding discovery, the pictures we never got, the other two body cams we got later, and the judge decided we couldn't use them. The body cam we're using today, we got to the defendant very early in the case. This case, I would assert, is closer to the Shaw decision. You've got them served properly, failed to appear. We have another one where they refused to testify, one where they refused to testify because they weren't no longer in the mortal realm. I think that those are the cases that are more guiding to Your Honor, and I'm not going to belabor the point any further unless you have questions.
So the trial that was attempted in Paran that ended in the change of venue, is it correct that there was the ability for, I guess that there was direct communication, hey, be here at 8:30, phone number, whether it's you or your staff or investigators? Is that representation correct? Or she just show up on her own, of her own volition?
Well, I don't think anybody contacted her like that day or the day before. But when she was served, we made sure to have it with us and to in case we'd have to file it. In the case of Deputy Toll, yeah, they have a place where they leave the subpoenas for the police officers. He had a vacation the weekend and the day before that last trial in Peron and wasn't able to make it. Now, you know, I'm not gonna go into huge amounts of detail, but if you have a witness, the only person who saw this happen would be the Blundos. If you have a witness that potentially doesn't remember everything that happened, then you can give them a document that they wrote out to refresh their recollection. If that person says it didn't happen that way, then the statement is one way to impeach her, but the deputy told would be another way to impeach her with actual video. And that's why we believed he was an essential witness and that he might have to testify. Yes, she wrote this down. She wrote this statement. Yes, that's her. My phone was on in front of my staff when I got the call from Mr. Fumo, and I left with the impression there was nothing more to do and she would be there at 1. I'm not going to tell you what was exactly said because these are longtime colleagues of mine, and frankly, what we heard or misheard or heard right is really not my point of contention.
Thank you. Ms. Armeni?
Your Honor, I don't think I have anything to add except for the fact that Melissa was placed under oath on Friday, and I think she is happy to be placed under oath today to confirm that she did in fact get a phone call on the day that we were in trial, that we were commencing trial, I should say.
Back in the 20.
In August, yes.
Yeah, and I can't tell you that that's not right. I think, the problem when you're in court is you're organizing, getting jurors down, and then scrambling for witnesses.
I don't know where the difficulties of trial work, how hectic things are, with the record the Supreme Court usually gets doesn't adequately convey that, or the pressure of decisions such as the one in November when you have 13 people sitting there you're looking at. You haven't even questioned them in voir dire about the following week if there's even going to be continuance. I mean, those things I think they get lost in the shuffle, and the Supreme Court completely is left in the dark. My advocacy career was recent enough. I'm well aware of those. Ms. Blundo, it's a fairly key issue for me. Do you have information regarding the August trial and the methods of communication?
Am I able to speak to you from here?
Yeah, just yes or no to that.
Yes, sir, I do, and I have documented proof from my phone bill.
Okay. Why don't you come on up? That's a key question for me. Please raise your right hand. Do you swear or affirm under the penalty of perjury that the testimony you have to give will be the truth, whole truth, and nothing but the truth?
I do.
Please be seated. So the trial was late, so the last trial that ended in a, sorry.
That's okay. Is it easier for me to stand for you?
That's all right.
I don't mind.
Ended in a change of venue coming up here. What's your recollection of the circumstances regarding you showing up to court down in Pahrump that day?
As the subpoena states, I called the phone number the night before, or the evening before around 5 o'clock. No answer. Mr. Glennen, and we'll have to make sure that I have the correct phone number for him. I believe I do. Called me back the next morning and told me that that the trial was going forward and asked me to attend. And it was at about 9:04 a.m., I believe, is what I'm looking at.
Or if it was Mr. Glennen?
It was Mr. Glennen himself, from his cell phone.
And you're using online records from your phone
Yes,
company?
sir, from my Verizon phone bill.
Okay. And what's the phone number that's coming from?
I believe his number was the 775. I have a couple, so I'm not 100% sure, but if I'm recollecting correctly, I have 775. Is that your phone number, sir?
Yes, Your Honor, that is.
Okay, what time is that?
9:01 a.m. 9:01
On which day?
on August 24th, if you would like to see it.
Yes, please. Have you screenshotted this, have you just
No,
looked it
I
up?
just looked it up just now. You can see it's on my actual bill.
It's incoming 1 minute.
Yes, sir.
Either council wish to see this. It appears to be a Verizon bill, talk activity is the label of the stream. The billing period is August 3rd to September 2nd. It's got Melissa Blundo with the 702. That's yours?
Yes, sir.
Okay. Okay. Does either council wish to verify this or challenge it?
I don't wish to verify, but I would ask maybe if Mrs. Blundo doesn't mind taking a screenshot of it, and perhaps we can mark it as an exhibit to our motion to dismiss.
Yeah, it's fair, Your Honor.
Okay. So if you could take a screenshot of that and then we'll have you email it to my clerk.
Do it now.
Okay, it's K. Yes, at Washoe, it's WASHOE, county.gov.
How would you like me to put it in, what would you like in the subject line?
Phone record, Blundo.
Okay.
Yes.
Should be on.
Thank you. Any questions of Ms. Blundo beyond mine, Mr. Armeni?
No, Your Honor.
Mr. Glennen?
No, Your Honor.
Okay, thank you. Any additional, Ms. Armeni will have the last words for motion, although it's kind of like a motion to suppress where the state, once there's a prima facie issue raised, they essentially got the burden overall. I think that's a fair interpretation of the heavy burden standard. So any comments upon the impact of this information that we just received, Mr. Glennen?
Yes, just, it was somewhat surprising that she had called me when she was represented. And so I called her back personally, and when she is represented, I've been keeping in contact with her attorneys. So I think that's maybe not the only proper thing to do, it is the proper thing.
She, I'm not sure I understood the phone record correctly. Speak up so that the.
If you need me to come back up there, I can, because I'd like to address that. I'm still under oath, correct?
Yeah, hang on a sec. We didn't get this, didn't come through in a copy more. Yeah.
Try again, I apologize. Did it come?
This came through in partial format.
It's weird. Just took a screenshot.
If you
Oh,
forwarded the
I think
website instead of
If
the,
I did, I apologize. It went to a different page. But
Your Honor, just for record, if she downloads it and then sends it, it might be actually easier and clearer. Downloading a PDF form.
yeah, a
it'll be
screenshot
the whole
too.
entire phone bill.
Yeah, the screenshot of the page is
Yeah,
good ideas.
I got it. I did the right page. I apologize. Can you repeat the email for me? I'm sorry.
Okay, R-A,
Oh, there it is. Paola, thank you. Should
and so the call, when we get it, shows that it's an incoming call.
Yes, sir.
And then, had you called, you called the PA's office or Mr. Glennon prior to that?
What happened was I actually spoke with my attorneys because my understanding, when I was served for that hearing, I called Ozzie and let Mr. Puma and let him know that I would serve at home. He was surprised because they had let Mr. Glennon know that I had representation since the common practice is for my attorneys to be notified and they would accept service on my behalf. I had called him and asked him, have you heard from Mr. Glennon? What's going on tomorrow? Does he need me? Does he not? Is anything, Ozzie called me. I have not heard from Mr. Glennon. I've reached out. There's no correspondence happening. I said, okay, so what would you like me to do? He said, go ahead and call the number on the subpoena so that you have record that you called, because it tells you to call the evening before the day before to make sure that you are required the next day. So go ahead and call the number. I didn't get an answer. I believe I left a message. I could probably see I don't remember the number, but I'm certain I can find it. And then I got a phone call back from Mr. Glennon the next morning stating that the trial was moving forward and he would need me. But he did not call my attorneys, he called me. And there was no, Mr. Fumo asked me to go ahead and call the number, and they told me to stay put until Mr. Glennon got a hold of me because they had not heard from him at all.
So then he called you the next morning.
Then Mr. Glennon called me the next morning, the morning of the trial at 9:01 a.m.
Why not call again before this November 8th one where you didn't show up?
Because at this point, he had had some communication with my attorneys, and what I understood, but there had been at least established communication to some degree between August and then with my attorneys and no longer communication with me. So I was relying on the communication with my attorneys at that point, which is why I told you on Friday, my precedence, I went on the precedence of this, which was, at that point, I knew we had had conversation to some degree. Mr. Fumo told me the exact same thing, and I have it in text message of, Tom said, Glennon will be calling me sometime, I should expect to call him on Monday. And he never got a phone call, which is what my voicemail, if I can submit that to you as well, which was why I stayed put, because he had, as 11:48 or 11:49, something in the morning before, had stated that he had not heard from Mr. Glennon yet. And if he did, he would call me, or if I did, because of what happened last time, to give him a phone call.
People are assuming things on all sides. Okay. Thank you. Make sure we have the same.
Yeah.
I may have to just send you the entire thing then, because I was on the 24th at that point, to the screenshot.
Can you pull it up?
I sure can. Do you want to that date or just the one with that?
Just that portion. Okay. We'll make sure we have a copy of that for the record. Any questions or argument based on this information? Mr. Glennon?
Yes, if it would please the court, maybe one further question.
Yeah, go ahead.
when you called the number the night before in August, do you remember what number you called?
I don't, it was whatever was on the subpoena, I believe. I can look at my phone bill. What number would be printed on the subpoena, because I don't really know.
I would guess 775-485-6352.
Oh, I guess I called that at 11:02 a.m. on August 23rd. So the day before in the morning. Yes, it says to Goldfield, Nevada.
And how many minutes?
It says 3 minutes. So I believe I didn't leave a message. And there's prompts whenever the automated answers the phone, so I have to listen to that.
All right, nothing further.
No, Your Honor. Thank you.
Okay, any argument on how this new information impacts anything?
I think she just confirmed my argument that, I think there was a question of fact as to whether she in fact, he called her or not. I think she confirmed what I submitted to the court, an argument that he did in fact call her on August 24th of 2023.
Okay, I've gone down the, then you can go ahead and see again. Thank you.
May I answer one of the questions that you asked him? As far as you asked me why not call him the night before on the November 8th?
Yeah, you said that you didn't because of the.
Correspondence between him and Ozzy.
Correct.
The other reason is because I knew that on the 24th as well, I knew that I would just be leaving a message and he wasn't going to, but basically because of Ozzy. And going upon me having to leave a message the previous time too, and then not hearing anything back until 9 o'clock in the morning as well.
Okay, thank you. So I've gone down this road because sometimes the smallest fact sway the case one way or another. So this issue of the ability of the DA to call, to verify, to check under the circumstances of this case, clearly piqued my interest. The DA's position is consistent with that. At the last trial, when it was continued, it impacted my decision quite a bit. And it was, copies for counsel.
Yes.
And I've highlighted it throughout the hearings. Mr. Plumo, Mr. Pizarro, well-known attorneys, good attorneys in Southern Nevada, the general deference that someone gives to appointed people who are not appointed, but people who are represented, and you go through the attorneys. And that's the state's position currently is, look, I was still deferring to that process. This opinion had been served, it had not been canceled. The court confirmed last week with Mr. Pizarro that the witness was not called off. The witness and Mr. Pizarro relied upon, hey, this was confusing at that hearing. And I presume the defense's position, Mr. Armeni really hasn't, obviously hasn't changed, but the history shows that there is an ability to check on things. There's was or is a known phone number and an ability to reach out if need be. And so your position is that should have happened. It didn't. That's another circumstance in the defense's favor. Is that right?
Yes, sure. I mean, I think our biggest argument, because I respect the court's decision on Friday and what the issue with the subpoena is that the subpoena said 8:30 and she wasn't here at 8:30. So yes, he had the ability to contact her, or Ozzy for that matter, at 8:30 in the morning to confirm what was going on, and in fact that they were going to be there at 1 o'clock when she wasn't here at 8:30.
The last continuance in November, the court had made the record, again, me trying to help the Supreme Court upon any review of the realities of trial. Witnesses not showing up right away at 8:30. Usually communication between the state and their witnesses, letting them know so people aren't just sitting around waiting and wondering while we're taking care of other business, taking a jury essentially that's going to take quite a while. At the last hearing when I was making those statements and finding that wasn't completely unreasonable on the state's behalf, and I went back through my notes. It was the phone call that followed up the text. My recollection of the history from the day before the last trial, that would have been November 7th, I believe. Mr. Fumo leaves messages at Mr. Glennon's office. Mr. Glennon responds later that day, is your girl going to be there, something to that effect. Mr. Fumo responds something similar, but then they end up on the phone. Mr. Fumo and Mr. Glennon have different takes on the conversation, but it's clear to the court that the gist of it, or none of it, was that Mr. Fumo has not had contact that day with her. It sounds like he tried to reach out, she wasn't available. There was a presumption that perhaps she was on the road, and in that conversation, Mr. Glennon was like, hey, well, we're not going to be here till about 1 anyway. And it was left at that, and it appears that nobody did anything after that. That's my recollection of the testimony from last time. Any quibble with that, Ms. Armeni?
Your Honor, I don't have a quibble with what you're saying because I think that's accurate. My quibble is more so with, we've heard about this text message, but there was no declaration to that effect in the opposition. We don't have a copy of the text message. So, to the extent that that's available, I'd like that read verbatim, because then we're not guessing or there's no impressions. It's the exact wording, and that's why we submitted the declaration of Mr. Fumo, because I understood I was getting text messages and reporting them back to the court, and frankly, we were doing what we could at that moment in time, but when we had some time to actually put together, we got the declaration from Mr. Fumo, so the court knew that it wasn't coming from me, it was coming directly from Mr. Fumo. So to the extent there's this text message that apparently is making these representations, I think that should be read verbatim into the record.
The text that Mr. Glennon would have would be essentially, is your girl going to be there, in some sort of response back that's not very helpful. It was a subsequent phone call between the two that Mr. Fumo's doesn't entirely explain, and then Mr. Glennon's recollection is a bit hazy because of the passage of time on that as well.
Right, and that's my concern, is the recollection has been kind of hazy. I mean, I think Mr. Glennon represented even when Melissa was here that he did not call her, and now we've got the record that shows that he did call her. So that's where my concern lies. If we've got something, because I understand memories, it's hard to remember everything. I certainly understand that. But to the extent that we've got a text message that says whatever it says, I think it's important that that is read into the record or as part of the record, so we know exactly what the communication was in the text message.
Because my concern is more of the follow-up conversation instead of the veracity of, is your girl gonna be here, and some similar clip back. I don't see it being super helpful, but Mr. Glennen, anything on that? And that was taken under oath.
Yes.
The last hearing I incorporated, so that an affidavit issue, I guess anything you wish to address is an officer report on that, or any additional information.
You know, I would have to say, one, that particular phone is sitting at the hotel room. It is not gonna be immediate help to us. I don't think Your Honor wants to wait, you know, go through an hour or so for me to go get it and tell you what it says. My recollection here is that when I said message, it was actually a voice message. And when I followed it back was when I got the impression that she was on her way. And I said, we'll do it one. And obviously the conversation itself is not going to be recorded.
Thank you. As far as any decision in this matter, the case law, looking at Pilton, 103 out of 418, is that when double jeopardy attaches here, we had a jury selected and sworn, double jeopardy definitely attaches. If there's going to be a continuance after that, and a trial on the same charges, twice putting a person in jeopardy, unless there must be manifest necessity or ends of justice, and I think they couch those as the two different methods to overcome the first hurdle of prosecuting someone the second time after a jury's been sworn. So manifest necessity or the ends of justice. Then you have the prosecutor's decision to proceed to trial, whether it's excusable or inexcusable negligence, and then something that doesn't really apply here, whether the defendant had essentially goaded the state into the need for a continuance or a dismissal. I don't see that third prong coming into play, the manifest necessity is not explained greatly. In the case law, it's described as a high burden. The alternate ends of justice, I think it was from Armeni. Ends of justice, what it talked about, failing to find it from one of the cited cases in short order. But what it mentioned was the lack of appearance of a witness, which would essentially gut the state's case. And here, I have no doubt that Ms. Blundo is absolutely required, told, and no representation that the case could be carried on him, it could be started, there could be some circumstances, perhaps some statements, but they would put us in the ground of no corpus for the underlying charges, so she's absolutely necessary one way or the other. So there's a justification there, end of justice not appearing, but the manifest necessity for the continuance, frankly, in my estimation, with similar grounds, Ms. Armeni's more or less, well, she hasn't conceded that, but she's pointed it out and noted that the real fight here is in large part over the prosecutor's decision to continue forward under the circumstances. And I thought about it a lot over the weekend and late last week, the interplay there, this manifest necessity. Necessarily, I think, if you're going to separate that into one element and then the decision to proceed forward nonetheless, as a separate element, that the decision to move forward under the circumstances definitely plays into whether there's this manifest necessity. Because if the prosecutor's conduct leads to the confusion, that manifest necessity is definitely a minimum muddied. I don't think it's a clean someone doesn't show, therefore there's manifest necessity. The totality of the circumstances is what the Supreme Court's told us to look at, and here in Nevada they've broken it out, but I don't think you can cleanly separate these from one another. So the manifest necessity is an issue, and it's a bit muddy. It's a little troubling that the decision to proceed to trial, whether that was negligent or inexcusable negligence, comes into play highly in this case. The DA in this matter relied upon the service of a subpoena. They're usually entitled to do so. This one is a bit unique. The witnesses traveling from the southern half of the state. The jury being seated in at least a 6-hour drive from the county where all of this took place, where the witnesses are, within an hour or two of the parties themselves. The service of a subpoena, no further communication. The witness was definitely not called off. Mr. Taro Fumo engaged to represent the victim. That there was no call by the state to Mr. Taro or Fumo to find out what exactly is happening, or I guess, or to inform them what exactly is happening. There was a minimum call to comply with Marcy's law to verify Ms. Blundo's continued desire that the case not go forward. That was some point the week before trial. There was no communication from the DA's office to Blundo directly or to her attorneys that the negotiations that were attempted over that weekend before trial were not fruitful. There's somewhat of a reasonable assumption Blundo's relationship. Noted that the subpoena was served at their joint business. They're definitely, it appears to the court, to be married, communicating, to be working together, to be knowing one another's business. But that is an inference. Every relationship is different, and I don't have any facts before me one way or the other on that, other than the inference that they would know these things. And the next thing that happened was Mr. Fumo reaching out to the state the day before. There was some voice and or text messages that weren't extremely helpful. Then there was a conversation that day before where, in the light most favorable to the state, Mr. Fumo would have represented. Haven't talked to her, don't know where she is. assume that she's traveling north, but I don't know. I haven't been able to get a hold of her, and the state inferred from that and relied on that Ms. Blundo was in fact likely traveling north. And the inference is the only thing I have likely with her her husband, but that is an inference and an assumption. Then the next day, Ms. Blundo was not here. The trial commenced, the jury was selected, and then the motion to continue was, our motion for continuance / dismissal, I guess mistrial. I need to be clear. There's a motion for continuance granted. Essentially, the question the court posed back to the parties is, do you want to wait till tomorrow morning? Do you want mistrial? And the mistrial was declared with the unlikely ability to get Ms. Blundo here in short order, no representations one way or another, no contact one way or another. There were no phone calls from the state to Ms. Blundo that morning, before picking a jury, or during picking a jury, or before they were sworn mid-morning. The state has shown up and has an assistant with them who could have engaged in that process to verify. The state was relying upon the subpoena being served and the representation by Mr. Blundo, Mr. Pitaro, and Mr. Fumo. I'm not reaching out, I'm not double checking, I'm not verifying, I guess I'm not invading that relationship because they're represented. I'm going to rely upon the conversation the afternoon before and my statement being the state to Mr. Fumo. Won't meet her till 1 o'clock, and that information would pass through, I guess, to Ms. Blundo, who then would be in a position, if she got information right away, to drive, get here at a reasonable hour and be available. The state assumed that was going to happen. Didn't double check with Ms. Blundo or Mr. Fumo or Mr. Pitaro before the jury was sworn. Last time I was under the distinct impression that there hadn't been any precedent for direct communications, and that's changed today. Ms. Blundo calling the pre-recorded line essentially, or office to verify the complete the subpoena, and then I called back. She didn't re-engage in that process. So on the one hand, she clearly could have. She knew she was served. She couldn't. She chose not to come. On the other hand, the state, knowing she's MIA, doesn't do much beyond that. Not a phone call, back out, whether it's to Mr. Fumo or Mr. Pitaro or Ms. Blundo that following morning, like there was the trial that resulted in a change of venue in Pahrump. The defense is asking me to look at this, and I think it's a close, rough call in light of the history of the case, to shade it towards, hey, the state should have been under an even higher burden, or these facts present make the call for negligence fall much more toward the excusable or inexcusable negligence. the dismissal without prejudice, understandable. Things happen, it's the state's right. The only prejudice to the state then is that any subsequent prosecutions need to be summoned in for discovery issues. Still don't know exactly what the issue was, but Judge Glassen fashioned a remedy saying, hey, regardless of why this information is unavailable, you don't get to use it to refer to it or call any witnesses who would have seen it. That's a bit troubling, but the next thing is our case. I can't, I'm hard pressed to hold it against the state that the attempts to pick a jury in Barone somehow should be held against them. And in fact, Ms. Armeni didn't really ask me to. Ms. Blundo did show up at that one. There was communication. The state was told essentially the entire case is going to fall on her because I'm denying the request to continue. He was told his absence. So the state said, yeah, we're going to go through with our one witness. Then we get to the November attempt here. I came in fully prepared to say, after looking at the case law, manifest necessity, the witness is under subpoena. They have the attorneys acting as intermediaries. The attorneys were informed within driving time that their client would be required. It was late, and shortly before. There was some ability to have some direct communication, but on that first prong, the manifest necessity or ends of justice, the missing witness in those circumstances, I'm troubled, but I'm convinced that the manifest necessity or ends of justice is met. The harder call is the decision to actually swear in a jury under those the fuzzy question of whether she's coming and the assumptions that she's coming and the assumptions that the information is going to be passed along. This Blundo reached out before the August trial, did get a phone call back in the morning of trial. That situation is markedly different from what we have here. They're all located in Pahrump. They're all close by. Here we have a trial being held in Washington County. Like I said, a good 6-hour drive away. There's a question regarding whether or not Ms. Blundo is coming. The state, based on her showing up last time, had reason to believe she'd possibly show up this time, but her attorney hadn't heard from her. They didn't reach out and make a call to verify. It's understandable that a witness wouldn't be expected to show up until 1 o'clock. So the fact that she wasn't here at 8:30 isn't terribly worrisome to me, but the lack of a double check with an attorney or a phone call to the witness, anything late that night, the 7th, early the 8th, the morning, the 8th, when we're talking about a heavy burden, is this inexcusable negligence as opposed to what I'll call mere negligence, and looking at the facts of the cases, they're not extremely helpful in determining the issue. We have facts where a witness tried to commit suicide. That's not the prosecutor's fault. We had cases where the prosecutor moved forward and called a witness, essentially knowing and having been warned by the defense and by the court numerous times. This witness was represented by the current defense counsel in the case, causing great issue. Those are clear situations. The witness tries to kill themselves. The state's not at fault for that. The situation where the state where they essentially hit the ball, not saying whether or not they were going to call this witness, made the decision at the 11th hour against the state. That's easy and understandable. We have the other cases where witnesses weren't even served. I referred to them before. One of the witnesses, I think it was in the Downham case, didn't show. The state wanted to dismiss the whole case instead of simply two charges, but they have not even tried to subpoena the witness. That's a far cry from what we have here. We have Cornero that Donovan was relying on two criminal defendants who have pled to show up to sentencing to then hopefully be called at the trial that happened to be set the same day. Also, far cry from what we have here. Not a subpoena. Here we have a subpoena, but we have the lack of communication. Is it reasonable? Is it? I guess what's coming down to in my mind, it's understandable how we got to where we are right now, but understanding it, appreciating the complexities of the trial situation is different from what should have happened when we're balancing the constitutional right, when we're having a case and tried in a different county, an assumption that a witness is MIA for unknown reasons is going to be here, and not checking on it super close, because you do have a served subpoena, unlike any, especially down or Cornero. You've got a served subpoena, there's an expectation. It's clear in this case from the testimony last Friday or information last Friday that the witness was not called off. We're coming, I guess, when I'm trying to synthesize these facts and compare them to down in Cornero or Houghton or Hollowell, those were cases where either the state didn't subpoena somebody, their case fell apart in the middle of it, or they chose to go forward knowing someone is not subpoenaed. Here we have the choosing to go forward based on a served subpoena. No verification of a MIA witness who's coming from afar. Relying on the custom in our industry of telling an attorney, this is my paraphrasing, essentially, the state telling Mr. Fumo, look, we're going tomorrow, you are her attorney, I won't be here till 1, but Mr. Fumo is going to follow through, at a minimum, leave a message. not entirely unreasonable. It allows for information to come back, like, hey, I can't, I didn't, I don't have a reliable car, you know, whatever it is, for a decision to be made. But Mr. Glennen would expect some sort of information coming back. Yeah. So repeating myself, the difference, sorting through understanding what happened and why it happened is, and comparing it for this case law as opposed to what should have happened and is what should have happened, what was actually required to. The history of the case, usually not that compelling to the problem that arises instantly. The dismissal without prejudice doesn't bother me, but it is a small piece. The discovery issues that dealt with, the remedies were harsh, sort of heightened some concern for the case in general. Definitely focus in the presentation because it's limited what could be presented whole, not being served in a normal, attempted to be served in a normal process for the last trial. Yes, the legislature did allow for service to law enforcement by subpoenas, and probably before that and after that, still common to send it over to the offices, sitting in boxes waiting for deputies or sergeants to actually see them, review them, sign off on them, and send them back. We're talking a jury trial here, though, and no small trial, one that already had a dismissal, one that had discovery issues, and that went wrong. And so now we're having witnesses travel somewhere else. We're told they're not, we don't know where they are. I said earlier, the smallest of facts often make the biggest of differences. Going into many a trial or hearing, having a preconceived notion as to where I'm going, and the smallest thing will change my mind. Here, not even double checking. That following morning or before jury is sworn, with the history of the ability to do so, even with that deference to Mr. Kuno, and how attorneys usually try to work with one another. I think this is a case where what should have happened, given the distance in the history of the case, the distance that they're traveling, the assumptions that were made, frankly, touch more care should have been exercised. So I'm going to fall on the inexcusable negligence. I don't think it was reckless. We're dividing extremely fine hairs when we're talking negligence versus inexcusable negligence, splitting that hair. It's frustrating that we've got probably 60 people downstairs, but I didn't force the hearing to go before today. I'm not sure the parties would have been fully ready before today. We did almost want to be able to clarify some of these last little issues if we wanted last week, but Motions were just filed, opposed, replied to. I'll have to bring the jury up and let them know that I'm going to find the double jeopardy precludes this. County court staff will let me know. We'll bring the jury up. I'll let them know that their services are not going to be needed and thank them. One of the tougher and harder calls I've had to make in my career. The general default is that cases should be heard on their merits. And it's a shame every time that the case is not heard on its merits. I'll be called once the jury's back upstairs.
All rise. Yes, sir.
Good morning, please be seated. Ladies and gentlemen, thank you for coming. It's no small thing to ask a jury to come in, to donate your time. On the flip side, it's a very important part of our government, part of our society, a double check to make sure that decisions that are large ones that impact people's lives are made fairly. In this case, it's one where a jury gets to make that decision. The judge gets to act as a filter and only give you what information that legally is relevant and arguably reliable, and you make the call. What do we believe? What do we not believe? The jury service is not deciding is this person a good person or a bad person, but back on this particular day, what are we convinced beyond a reasonable doubt happened or didn't happen? You've come down, you've answered that call. We could not go forward without you and your participation. It's a wonderful double check, so the judges aren't the sole ones making those decisions. Parties can waive that and have judges make the decisions. In some cases are appropriate for that, some aren't. All of this to be said, you have come, you have answered your call. This case, for some procedural reasons, will not be going forward today, so you will be released. I have had you wait quite a while. We were expecting to have you up here at 8:30. There was some legal arguments that took place, some difficult calls that needed to be made, and this matter won't be proceeding forward today. So again, your service will not be needed. The only upside to this is that by showing up today, my understanding is that for Washoe County purposes, you'll be excused for about 2 years. We do have federal courts here. They're a different authority. You could be called to theirs. I know Washoe County essentially credits you if you had been called to a federal jury. I don't think the feds give credit the other way, so you very well might be. Some people are relieved. I don't have to make a decision, or I didn't want to sit. My comments in that regard are it's understandable. People avoid conflict. They avoid making decisions unless they absolutely have to. There's a rare breed of people who really enjoy making decisions that involve others. But I'm heartbroken to some degree that you don't have that opportunity today. There's an individual that we've spoken to after trials who come in and they say, I was going to say whatever it took to get out of this. I had preconceived notions of what it was going to be like. I didn't want to do it. And oh my gosh, I would do this once a week, once a month, the rest of my life if I could. It's actually a fantastic process. So I'm heartbroken that you don't have that opportunity to, at a minimum, learn that lesson or engage in the process. I'm not going to waste any more of your time today. You're free to go about your business. If you need paperwork for an employer or for school or something like that, acknowledging your presence here. We'll make those available to you. You'll need to go downstairs, and will it be in the room they checked in or at the windows? Okay. There'll be someone available at the main glass horseshoe shape of windows to give you that type of note if you don't need one. You're free to go. The parties and I thank you for your time and the time that you gave us, the hour where, like I said, we expected to have you in here and start business at 8:30. And I took that hour to make some legal calls. So this, again, is not going today. And we thank you.
How much first?
Come on.
Okay, the jury has, please put the records back on in case there's anything else. The jury has left, put back on the record with the parties, State versus Leonardo Blundo, RCR 2023-124588. There might be a question, at least in Ms. Blundo's mind, regarding the contempt ruling from last week. This was no small call, no easy call for me. And my ruling does stand. I learned today you had the ability to call out. I knew full well you have the ability to speak with your attorneys. I'm not looking for any additional information. I think the inferences were fair that I knew this trial was likely to be going. So that $250 that was suspended is not being imposed. You showed up, but the $250 that was ordered by the end of January needs to be paid. Your attorneys are free to file things if need be and challenge that decision and to potentially appeal that if need be. Otherwise, we expect that payment no later than the end of January. Like I said, if we were simply going to pay it, the sooner the better, Ms. Blundo. So we all know where we stand. I'm not saying you have to do it today. There's legal decisions to be made whether you're just going to pay it or not. And then the parties, this truly was one of the hardest calls I have had to make. As I stated before, understanding why something happened and having it be understandable, comparing it against these fuzzy legal standards, surprisingly difficult from time to time. The decision fell the way it did for the reasons I had stated. I appreciate both sides' professionalism and patience with me. I tend to get into the weeds and perhaps have been accused of overthinking things from time to time. And frankly, it's just how I'm wired. So disappointing to the state for sure. I acknowledge that, but it comes with the job and I bear the burden of the decision. Is there anything else that we need to take up?
No, Your Honor, can I just get clarification if Mrs. Blundo was going to pay that contempt today, would we just give the case number, Mr. Blundo's case number, is it attached to this case number?
Yes, I didn't, last Friday, I had some other commitments, so I didn't get the written order out. I'm gonna follow up with it, that if she makes a payment under this case number today, we'll marry it up. I'm gonna do that order before I leave today.
Okay.
So if she was just to pay it right away, yeah, just under this case number. We don't have it set up and tracking differently in our cases. I issued the order of contempt in this particular case. There might be some wisdom for us to look at our procedures. Do we assign it some different type of case number? That didn't happen, so long story short, in this case.
Okay, thank you.
Anything else?
Thank you, Your Honor. That's why you make the good money.
Can we go off the record?